Hi everyone, how are you? Welcome to part 14 in my narrated series with many balls. Many crystal balls now. I keep finding them now that I'm looking. I found the cutest one in Marshall's today and I couldn't help it. I it was this crystal ball and this fortune teller lady, and I just waited until they weren't playing music in the back and then took a little video and said, "Don't miss part 13." Oh, boo boo, are you going to leave? I said, "Don't miss part 13 of my narrated series with many balls." Because it's not just about this crystal ball from the Dollar Tree anymore. I'm finding them all over the place. It's like I was supposed to be doing this. Like everything fell into place in the universe, and I'm exactly where I was supposed to be, exposing the truth out of what is really going on with this lawsuit. If you ask Katie Joy, oh, nothing's going on, and the other side just isn't doing anything. That silly 7M doesn't know what to do. I'm telling you, there's a whole lot more going on, and that's why they call me Backstory Tabby, because I've got the whole backstory for you, and part 14 is right here. I will turn on the light in just a second, but little Boo here was just looking at the crystal ball, and I didn't want to bother him. Aren't his eyes pretty? Boo Boo. His eyes are kind of yellow right now, but they are green. He is a breed of cat called a Korat. And so unlike Tiger, he comes from the lines of monkeys. His breed comes from Thailand. And see how he looks like he's smiling on the side? I'm going to put up a little picture of him when he was a kitten 4 years ago, a little flashback that came, and he looked like he was smiling then too. He has this little upturned smile. And a Korat's eyes stay yellow until they're fully matured. And so his look green most of the time, except for when he's got a little light going into it. But see his little smile? And then we got Ma Kisses down here. She's trying to figure out what to do down there. Yeah, you guys are trying to hound me for treats, aren't you? Uh-huh. Yes, you are. Yes, you are. I think you've already had your treat limit, though. I don't want to fill you up. So, whoa. Oh, sorry, Boo. I didn't mean to scare you. Can I read now? Can I turn on the lights and we can read? Are you going to read with me? Huh? I tell you, having a cat coworker, it's something else. They're so catty. Ha ha ha. So, anywho, without further ado, got enough light here. But, so part 14 I already have out because I was going to narrate on the go, but then we got all of this, we got several notifications that there was going to be a big storm with possible hail and thunderstorms and all that good stuff. So we're like, let's just go back home. And then there was no storm. It moved up north, which is great, but we really need the rain so bad, and we need what are you doing? We need just the air to change. It's just been dry and stagnant for a long time. Thank you, Boo. So these are out, and we'll just go forth with part 14. And here we are again. Now, these two motions that I'm going to narrate are also written by Jennifer Moore. And they are in that same time period, almost a year ago, in that November 4th time frame. So much was done then. So I'm going to narrate right here where we have, let's see. Let me get this in a better position. And to let you kind of know where I'm at with things, I am not yet 1/3 of the way where I need to be. I thought I was going to be able to get you all ready to where we were at, because that's all. I didn't think anything was going on, because really there wasn't. I hadn't heard anything from either side in the news or these YouTube streets, as we call them, to let me think that there was anything going on, or I would have been paying attention much sooner than I was, and I certainly wouldn't have thought that I could get through this in such a short amount of time. I'm still shocked at how much is going on. I'm going to tell you that much. So let me see if I can get this on here a little higher. We'll do this, and then we'll move the ball more into view there. And that should work. Now remember, mine is more of a listening channel because I'm not talented at all. So this one is Defendants' Memorandum of Law opposing an amended scheduling order. Okay, now this is just a little shorty. It's basically 2.5 pages. Once again, by Jennifer Moore for Troutman Martin Law, and it's dated November 5th, 2022. Okay, that's the when it was filed. So she actually wrote this and dated it November 4th, 2022. So this is just a little memo, and we'll get right into it because we are talking about the state of Minnesota and the county of Wright. And we are talking about case type, which is default in the district court in the 10th Judicial District. And we have 7M Films Incorporated with Robert Shin, Miranda Derrick, and James Derrick as our plaintiffs. And they are versus Catherine Mansky-Paulson, a.k.a. Katie Joy, and Without a Crystal Ball Limited. I can't think right now. I need to go to bed, but I'm not tired at all. Limited Legal Corporation, LLC. I can't think right now what LLC even stands for. I need to just quit. I just got to wrap it up. Never mind. I was just say LLC, just like it is. Limited Liability Corporation. So I can't think. Anywho, introduction. The plaintiffs, having missed the deadline to conduct discovery, have asked the court to amend its scheduling order. Defendants oppose this motion insofar as plaintiffs have failed to exercise even the slightest due diligence in preparing their case for trial. Okay, hello. You are the party that just a couple of minutes ago, in this same filing on 11/4/22 was saying that you couldn't do anything, and yeah, you were 30 days late because somebody's mother-in-law was sick, right? And you said that it wasn't fair that the other party went and filed a motion because you guys were 30 days late without even picking up the phone. So now how do we get this attitude? Like I'm saying, when they were face to face, this attitude wasn't there. Nope, not at all. Nope. It was a nice little grandma lady. So, their argument states, Minnesota Rules of Civil Practice 206.06 sets forth the process parties are required to use in order to prepare their case for trial. Within 30 days of the initial due date for the answer, the parties are required to confer with each other and prepare a discovery plan. Counsel are jointly responsible to the court for this process. Plaintiffs would have the court believe that it's defendants' fault that discovery has not occurred. The truth is that plaintiffs failed to engage defendants on the topic of discovery until the deadline for discovery had passed. Plaintiffs have not served initial disclosures as required under Minnesota Rules of Civil Practice 2601. Plaintiffs have not served discovery under Minnesota Rules of Civil Practice, page 33, 34, and 36. They have not identified witnesses they wish to depose. At the same time, plaintiffs seek to punish defendants by the Draconian measure of default. Okay, right here, she did. This is where these words came out that were just, Katie Joy just had the biggest freaking She was titillated. She was titillated with this language. And I remember hearing about this. I feel that her side dropped the ball, and then Katie Joy had the right to say, "What are you doing?" But it is my belief that her attorneys probably told her to zip it and not talk about this case at all. So with me looking into the crystal ball here, I am saying that the relationship between Katie Joy and her attorneys might be contentious because Katie Joy won't stop. She will not stop. She's just going and going and going. She's making her money in a time when most of us aren't. Does that make her win? Is she happy? What is the true definition of winning? Is it how much money you have? I don't think so, because I'm going to tell you. I went to Thailand and I saw people with nothing that came from generations and generations of having nothing, that they earned every cent they ever made, that they had some cloths for walls. They didn't even have a house. A house wasn't anything that would even be in their wildest dreams. That they worked hard, that they ate what they fished in the morning, along with the vegetables that were grown by their grandparents in the land. And I met them, and they were among the most happy people I've ever met in my life. And going to Thailand and spending time with the Thai people changed me. I will never be attached to anything materialistic because of it. And take anything I have. It's all replaceable except for people that I love. They're not replaceable. Anything can be replaced. Everything can be taken. The only thing I care about is those that I love, and those that I love I will protect. Looking at Katie Joy, do you see a happy person? I don't. I see a very miserable, unhappy shrew who is using YouTube as a form of escapism for the only role that is important. Right now, she claims that her child is medically fragile, so her number one priority, the place where she spends her time, should be with that child. He has coverage that does not require her to be online. That her job is not providing his medical coverage, allegedly. I believe that he is covered, her son is covered by our state, and our state has funds for children like hers. I do not receive any of those, and I've not ever accepted any on behalf of my child. I do know of them, and I do know that people who are close to Katie Joy and who know the situation well understand that her child is covered, and so she's not doing this to provide for her son's medical, and that is what is important. I am sure that her child would rather have a happy mom and a happy dad in a mud hut in the middle of nowhere, as long as there was laughter and happiness. Any child would. What is she getting out of this? What is she getting out of judging other moms and wives? How is that helping her situation? Money can't buy happiness. I know that we all like to joke and be like, yeah, let me try, because let me tell you, I could use a little money. But you know what? It doesn't matter. Money comes and goes. Love and true love doesn't. And children grow fast. And as much time as she is online, she's not watching that child grow. It's sad. It's sad. Overall, it's sad seeing the way that she is. I feel bad for her son. And I hope that at some point she gains some introspection and starts learning what her priorities are in this life before it's too late, before her child is grown. And it's just very sad, very sad. With that being said, her attorney pipes up here saying, at the same time plaintiffs seek to punish defendants by the draconian measure of default judgment when they missed a technical deadline to file an answer. And I said that, sounding as bitchy as this sounds, because Katie Joy is a whiner, and she is bitchy. And for some reason, she was allowed to find an attorney who matches that tone. Because when I read that right now, I heard it just like Katie Joy would say it, even though it's signed by Jennifer Moore. So I'm going to say it one more time because I read it to myself 3 times. As it says right here, at the same time, plaintiffs seek to punish defendants by the draconian measure of default judgment when they missed a technical deadline to file an answer. I mean, come on. You're very lucky that you didn't just have this whole entire case blow up. You should be very, very thankful that the judge didn't do what the judge could have done. And you shouldn't be sitting here lipping off saying draconian measures. Tisk, tisk, tisk. Well, then we go in here. And it says, notwithstanding the fact that counsel knew full well that defendants intended to answer, had been fully engaged in the litigation, and had always responded promptly to correspondence from plaintiffs as counsel. Plaintiffs seek to ask the court to reward the failure to engage in any meaningful act to advance the case under rules of civil procedure or the court's scheduling order issued pursuant to Minnesota Rules of General Practice 111 with more time. Okay, a year later, ma'am, you asked for more time and said you didn't know what to do because you were on vacation. Unbelievable. Unfriggin' believable. Okay? So it says, plaintiff's excuse for not complying with the rules of civil procedure and the court's scheduling order is that they had not been served with an answer. However, rather than ask about the answer, they filed for default judgment. Plaintiffs have now been in possession of the answer for over a month. However, they still have not served initial disclosures required under the rules or served discovery. Defendants might object to the discovery as untimely, but at least the plaintiffs would have established some good faith effort to advance their case. Finally, defendants' theory of the case has hardly been a secret in that it was laid out in defendants' motion to dismiss. The conclusion is, based on the foregoing, defendants ask the court to deny plaintiff's motion for an amended scheduling order. Dated November 4th, 2022, respectfully submitted by Troutman Martin Law by Jennifer Moore. Alrighty then. Well, okay. And then this next page here is just where it says Minnesota Statute 549-211 acknowledgement. The party on whose behalf the attached document is served acknowledges through its undersigned counsel that sanctions, including reasonable attorney's fees and other expenses, may be awarded to the opposite party or parties pursuant to Minnesota Statute statute 549-211. And there you go. Okay. We're going to move right ahead to the next page here. And this was a week later in that same year. So almost a year ago, as it's dated November 14th, 2022. And it's once again written by Jennifer Moore. All right. So once again, we're State of Minnesota, County of Wright, District Court, 10th Judicial District, in a case type of default. We've got the plaintiffs, 7M Films Incorporated, Robert Shin, Miranda Derrick, and James Derrick as the plaintiffs, versus Catherine Mansky-Paulson, a.k.a. Katie Joy, and Without a Crystal Ball. And this is a reply memorandum supporting motion to compel. The introduction. Once again, plaintiffs make careless errors of fact and law while seeking the most draconian of measures against an inexcusable error by counsel for defendant. Here, plaintiffs have 1. Filed an untimely response to defendant's motion to control. Hold on. So she used the Draconian in this one and that. So that was the word of the week. All right, noted. I just want to make sure I wasn't reading the same thing. So I'm going, wait a minute. I mean, once you drop a Draconian, you kind of got to spread it out over a period of time before you drop a Draconian again. But she's going to drop Draconians. All right. Dropping Draconians. Okay. Here, plaintiff says, filed an untimely response to defendant's motion to compel. Number 2, made absolutely no substantive arguments explaining why they should not be required to respond to timely served discovery. And number 3, misrepresented the record with respect to counsel's communications regarding discovery. Argument. Plaintiff's response to defendant's motion to compel is untimely and should be stricken. Oh. Minnesota General Rules of Practice 11504B provides that responses to motions must be served and filed no later than 14 days prior to the hearing. Since the hearing in this matter is scheduled for November 21st, 2022, plaintiff's response was due on November 7th, 2022. Plaintiff's response was served on November 9th, 2022, making it 2 days late. Accordingly, plaintiff's response should be stricken. Oh, yeah, she's saying it should be stricken. Okay, all right. Plaintiffs have failed to address the substantive basis for plaintiff's motion to compel. The sole defense that plaintiffs have offered for their failure to serve timely discovery responses is that they filed a motion for a protective order. The filing of a motion for a protective order does not magically toll the time for serving responses to discovery. The rules require plaintiffs to make timely responses to discovery and identify which requests were objected to on the basis of the purported need for a protective order. Most of defendants' discovery requests were non-controversial, seeking information that cannot possibly be the subject of a protective order. For example, some of the discovery requests seek information related to court records or property records. Some discovery requests merely ask the plaintiffs to identify witnesses or others who may have knowledge about the matters raised by this lawsuit. This discovery cannot possibly necessitate a protective order. Well, they got one, didn't they? Tea, as you know who says. And I'm actually drinking my blackberry lemonade. Tea. All right, then. Yet, plaintiffs have failed to respond to any discovery at all. For whatever reason, they believe that they should be entitled to bring a lawsuit against defendants while hiding from defendants any and all information that would permit them to formulate a defense. Plaintiffs do not want defendants to see discovery materials. Plaintiffs do not want defendants' counsel to have copies of discovery materials. Counsel cannot be expected to provide meaningful advice and assistance if they cannot have copies of discovery materials or discuss the materials with the clients. Okay. Plaintiffs have misrepresented the factual basis leading to these motions. It may be that the undersigned counsel at some point in the initial motions papers confused the date discovery was served with the date that plaintiffs brought a motion to compel. However, that would be a typographical error that is more than made up for by the sheer number of times that the memorandum of law states discovery was served on August 5th, 2022, and that plaintiffs brought their motion for a protective order on August 26, 2022. Moreover, the affidavit of Graham Martin is a detailed recitation. Okay, really? Recitation. 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 Why can't I say that? Recitation. Here we go. Moreover, the affidavit of Graham Martin is a detailed recitation of the communications and negotiations that led to the instant motions. The relevant facts are as followed. Number 1, the deadline for discovery was August 5th, 2022. Number 2, defendant served timely discovery on August 5th, 2022. Number 3, plaintiffs did not serve discovery on defendants. And number 4, plaintiffs, without complying with Minnesota General Rules of Practice 115.02, served and filed their motion for a protective order on August 26, 2022. On September 1, 2022, plaintiffs then advised defendants that they would not be responding to any discovery until after their motion for a protective order was resolved. These facts, as well as a detailed recitation of the negotiations around issues related to discovery, a proposed protective order, and the need for an answer, are fully set forth in Mr. Martin's affidavit. However, the above timeline shows that the motion for a protective order, motion for default judgment, motion for a temporary injunction, and motions for an amended scheduling order were simply window dressing for the fact that plaintiffs missed their deadline to serve discovery. Window dressing? What? I cannot. Simply window dressing. No. They didn't. Draconian and window dressing. No. Oh my God. All right. Mm-hmm. Aren't we quite the diva in this? What in the world? All right. Window dressing. The timeline also shows how plaintiffs do not intend to engage in due process. They are simply using this lawsuit as a means to bully Ms. Paulson into foregoing her First Amendment right to report and comment upon plaintiffs. You bunch of poopy heads. Oh my God. All right. Conclusion. For the reasons stated above, plaintiffs' response to defendants' motion to compel must be stricken as untimely, and defendants' motion to compel must be granted. Respectfully submitted. Troutman Martin Law, PLLC, by Jennifer Moore. And I mean, it's signed by Jennifer Moore. It's not secondarily signed by Graham Martin, but it sounds like they were both there. And maybe Martin is, quite wild. But I'm telling you, Jennifer Moore is just a nice little grandma lady. Couldn't hurt a fly. Nope. I mean, you would kind of expect her to be like a law teacher, kind of more, maybe, from my experience. Oh, hi, Boo, you back? You back, honey? Hi. And this was dated November 14th, 2022. What are you doing, my love? Okay. Boo, what are you doing? Now let's go over here and see if we have time for this. We're at the 30-minute mark, and I like to keep these at about an hour just so that they are not, just droning on and on. Let me see what we have here. Because this next one is by Amber Stavig. So I think we can do this next one in full in 30 minutes. What do you think, Boo? What do you think? What do you think, Boo-Boo? You want to listen to Mama talk? You want to listen to Mama? Okay. Is it okay, or do you need Mama to put you to bed? Huh? You took a good nap. You shouldn't be that tired. Are you that tired? Are you tired? Oh, cutie pie. You're so cute. You just want to listen to Mama talk? Or what do you want? What do you want? You going to go to sleep? You going to go to sleep? What are you going to do? What you going to do? You just going to stay here? Well, he just might stay here while we talk. Okay. So, if we go to the state of Minnesota, the county of Wright, and we go back to the plaintiffs who are 7M Films Incorporated, Robert Shin, Miranda Derrick, and James Derrick as the plaintiffs versus Catherine Mansky Paulson, a.k.a. Katie Joy, and Without a Crystal Ball as the defendants. And we go to reply memorandum in support of plaintiffs' motion scheduled for November 21st, 2022. Okay. So it says in the introduction. The introduction states. What are you doing, Boo? The introduction states. That was my chair. I didn't fart. I swear to God, I'd stand up and bow if I would have farted like that on live. But and it wasn't Boo. You didn't fart either, did you? My Tesla can fart. It has a whole little program where you can make it fart. It's quite impressive. They had it as a feature so that you could warn pedestrians when you were coming. But for some reason, a farting Tesla didn't go over well with the National Transportation and Safety Board. So they had to take it out. But for some reason, it was still left in my vehicle. And I can set it up so that it farts when you use the turn signal. But my husband doesn't know that I can set it up that way. So, yeah, don't tell Daddy. Don't tell Daddy that that's how I make the Tesla fart. What are you doing, Boo? You're going to look so handsome. What are you doing? What do you see over there? Oh, you see shadows, don't you? Boo. Oh, are you going to give yourself a bath? What are you doing? What are you doing? Okay, so the introduction is, defendants in this case have both failed to serve a timely answer in this lawsuit and support its rationale for failure to serve a timely answer. Although it is plaintiff's contention that defendants are in default and do not have a reasonable defense to this lawsuit, should the court allow this lawsuit to continue, plaintiffs respectfully request their previous discovery motions be granted. Okay. Right away, you can see that the speaking pattern is different with Amber. She's got it going on. She's a smart girl. She understands what she's doing. She understands the brevity of social media and its deleterious effects on our world and how much it has allegedly impacted her client. Default judgment. Defendants have failed to provide reason for their failure to timely answer this lawsuit. Defendants first claim that they have a reasonable defense on the merits of the case. Defendants support their reasonable defense is that plaintiffs have refused to engage in discovery. Defendants have failed to provide case law which supports its contention that a plaintiff's failure to provide discovery can defeat a motion for default judgment based on defendant's failure to timely answer a lawsuit. Defendants go on to state that independent media organizations have verified that Ms. Paulson's allegations are true. Defendant's conclusory allegation does not support a reasonable defense on the merits of this case. Defendants have failed to provide facts or law which support their contention that they have a reasonable defense to this lawsuit on the merits. Next, defendants claim they have a reasonable excuse for not answering the lawsuit timely. Defendants' reasonable excuses are: 1, they don't know the Minnesota rules of civil procedure. Number 2, due to Attorney Martin's family emergency, the answer signed by Ms. Hendrick was not filed. And number 3, plaintiffs did not give them a heads up that they would be filing a motion for default judgment a month after the answer deadline had passed. Boom. And that's where we see Amber coming in. We see her coming in with all of the smarts and confidence to say, what you're saying here isn't going to work. Okay? Boo. Do you have to look so terrified? Boo. He sees shadows because I have the lights up. So he's seeing my papers move and stuff, and he's just so funny. Boo. Please don't look this terrified. Boo, you look like a scaredy cat, and you're distracting me. Boo. Are you guys watching him? Uh-huh. Boo, you're so funny. Okay. Back to the case. Boo, stop distracting me. You're a cat coworker. You're not going to let Mama, because you're afraid of these shadows, aren't you? Are we in a scaredy cat? Oh, hold on, love. Let me help you down. There you go. All right. All right, that cat coworker of mine, I tell you. Okay. I'm telling you, catty coworkers. With respect to the answer deadline, plaintiffs outline the Minnesota rules of civil procedure when an answer is due following a motion to dismiss in its memorandum of law in support of default judgment. Further, plaintiffs sent numerous emails to defendants allowing them an extended answer deadline. This is proven in Stavig Affidavit example or Exhibit A through C. Several of these emails were sent after the deadline to answer deadline had already passed, as counsel was given multiple opportunities to stipulate an extended answer deadline and remained engaged via email with plaintiffs regarding this lawsuit. It is not reasonable that the answer was not served on plaintiffs until this motion for default judgment was filed. So I'm saying Amber knows her stuff. Regarding defendant's allegation that he was unexpectedly called out of the office, and that is why the answer was not filed, the attached emails and the signed answer support a different narrative. Attorney Kristen Hendrick supposedly e-signed the answer on September 2nd, 2022, not Attorney Martin. See defendant's answer. Further, from September 2nd, 2022, through September 9th, 2022, Mr. Martin and Attorney Stavig exchanged several emails regarding discovery. And that's in the Stavig Affidavit Exhibit A. Pursuant to the correspondence exchanged and the signing of the answer, it does not seem likely that defendant's failure to answer this lawsuit is due to the unfortunate family emergency of Mr. Martin. Plaintiffs have and continue to suffer prejudice as a result of this late answer. Each day that goes by results in damage to plaintiffs and their reputations. Defendants continue to post about plaintiffs as well as this lawsuit. Oh, no. Katie Joy, don't do that. No, don't continue to post when you're already in such deep caca, please. Just settle down and just don't. But what is Katie Joy going to do? Katie Joy's going to do what Katie Joy is going to do, and nobody tells Katie Joy what she's going to do. Except for Katie Joy. Okay, so it says. Plaintiffs have acted in good faith throughout this lawsuit to attempt to stop defendants from destroying their business, their reputations, their personal relationships, and defendants have failed to properly answer this lawsuit. As defendants' time to answer this lawsuit has passed, and they have not shown a reasonable excuse for this failure or a reasonable defense to the lawsuit on its merits, the court must grant plaintiffs' motion for default judgment against defendants. In the alternative, plaintiffs filed 3 discovery-related motions prior to defendants' failure to answer this lawsuit. If the court finds default improper at this time, the following are plaintiffs' reply memoranda in support of its discovery motions. Okay. Well, temporary injunction. Defendants have failed to support their argument. Defendants have failed to support their argument. The Dahlberg factors do not weigh in support of injunctive relief. I think that there's a word missing there. It should be that the Dahlberg factors do not weigh. Because it says defendants have failed to support their argument. The Dahlberg factors do not weigh in support of injunctive relief. It just doesn't flow right. Anyway. First, defendants argue that the First Amendment completely prohibits any injunctive relief involving free speech. The protections of the First Amendment are not limitless. Certain types of speech have traditionally been excluded from the First Amendment. There are several delineated exceptions to First Amendment protection, such as obscene speech, fraud, speech integral to criminal conduct, and defamation. These categories are well-defined and narrowly limited classes of speech that fall outside of First Amendment protection. Defendants next make the argument that as defendants are in the business of producing celebrity news, they should not be subject to current defamation laws. This allegation is completely unsupported by Minnesota law. Next, defendants analyze the Dahlberg factors and fail to support their contention that plaintiffs are not entitled to injunctive relief. A. The temporary injunction may be granted if by affidavit, deposition testimony, or oral testimony in court it appears that sufficient grounds exist in the Minnesota Rules of Civil Procedure, the proponent of a temporary injunction must show that the injunction is necessary to avoid irreparable harm. Irreparable harm exists when a party has no adequate legal remedy, usually because its injuries could not be fully compensated through an award of money damages. The irreparable harm must be established by verified affidavits or pleadings. Once irreparable harm is shown, a court must conduct a Dahlberg analysis to determine if injunctive relief is appropriate. The Dahlberg factors include the parties' relationship, the harm suffered to the plaintiff if his request is denied compared to the harm suffered by the defendant if the injunctive relief is granted. 3. The likelihood of success on the merits. And 4. Public policy. 5. The administrative burdens of enforcing the order. Okay. The balancing of harms favors the plaintiffs. The second factor involves balancing the harms to the plaintiffs if the temporary injunction is not granted against the harm to the defendants if the court provides injunctive relief. Contrary to the contention of defendants, the harm to plaintiffs if injunctive relief is denied would greatly outweigh the harm of the defendants. As outlined in plaintiffs' memoranda of law and supporting affidavits, they have already lost millions of dollars due to defendants' smear campaign against them. Defendants have failed to address the irreparable harm already caused by them at the expense of plaintiffs and instead focus their argument on how it is harm to them if they are no longer allowed to monetize the false and defamatory statements they have been making. As defendants have provided no case law to support this contention that free speech allows them to continue to publish defamatory information, plaintiffs have properly proven that the balancing of harms is in their favor. Oh, I don't know why she's not taking this seriously and stopping posting, but she truly believes she's right. I guess if she believes it, well then, must be true, right? The plaintiff can demonstrate a likelihood of success on the merits. The next Dahlberg factor requires the court to look at the likelihood that one party or the other will prevail on the merits. However, if a plaintiff makes even a doubtful showing as to the likelihood of prevailing on its merits, a district court may consider issuing a temporary injunction. Okay. If plaintiffs can show that they have a likelihood of prevailing on the merits in merely one of their counts, including defamation, then this factor weighs in favor of granting the temporary injunction. As plaintiffs have shown that they have a likelihood of prevailing on the merits of this case, it is proper for this court to grant a temporary injunction against defendants. Public policy supports the plaintiff's motion. The fourth factor, whether or not public policy supports the motion. In this case, public policy favors enjoining defendants' attacks against the plaintiff's reputation and business prospects. Defendants fail to address how public policy does not support this request for injunctive relief. The administrative burden on the court supports the plaintiff's motion. The final factor involves looking at the burden on courts in the supervision and enforcement of the injunctive relief. Defendants argue that plaintiffs' lengthy list will be impossible for the court to monitor because it is so burdensome and confusing. The example they wish to use is that there is a different... There you go. Wrong word. There should be a difference. On neither side. Neither side is proofreading. And it makes it really hard. Okay. I'm going to put this in there like that. The example they wish to use is that there is a difference between publishing statements that plaintiffs have been accused of human trafficking violations or that plaintiffs have engaged in human trafficking. The underlying basis of this lawsuit is that defendants have made false and defamatory statements about plaintiffs, including that there have been credible accusations of human trafficking. Due to the egregious nature of plaintiff's statements and her own alleged inability to recognize how accusing someone of human trafficking could possibly make her liable for defamation, it is even more clear that a temporary injunction should be placed against defendants as outlined in plaintiff's memorandum of law. Boom. Protective discovery order. Defendants in their memorandum of law opposing plaintiff's motion for a protective discovery order have failed to show a legally cognizable reason plaintiff's motion should not be granted. In fact, counsel's failure to recognize how their own clients' behaviors and statements are or could be construed as potentially leading to the public dissemination of highly sensitive information supports plaintiff's motion. Defendants argue that plaintiffs have failed to show good cause exists for the issuance of a protective order. This allegation is supported merely... Look at this. I'm not making this up. Look at this. Supported merely be defendant's belief. What is that? Merely be defendant's relief. That needs to be by. Let's go by. And redo this. Defendants argue that plaintiffs have failed to show good cause exists for the issuance of a protective order. This allegation is supported merely by defendants' belief that the posts, which are the subject matter of this lawsuit, were proper in the first place. Plaintiffs have specifically alleged that defendants have previously disclosed documents which were private, sensitive, and in some cases subject to a protective order. As outlined in plaintiff's memorandum, this dissemination of documents obtained during court proceedings and subsequent misstatements of facts and law about those documents are partially why plaintiffs are requesting a protective discovery order on this matter. Defendants' only defenses are: defendants' posts indicate that they are public documents available on PACER, and that defendants' statement, "discovery is about to get real," should not be construed to mean that defendants plan to disseminate information and documents obtained through the discovery process. Forgot a comma here. And there. And here. And that was the world's longest sentence, and it missed many commas. But anyway, these statements are contrary to the facts. Defendants have consistently and mercilessly posted filings from this case, letters between counsel, and have also posted depositions from other cases and misconstrued what the documents state. Boom. Stavig, Affidavit, Exhibit E. In addition to defendants' near constant posting of court documents and other things obtained through this lawsuit, she is also a purported weapon in an upcoming proposed documentary. Okay. Weapon. Okay, we got to do some commas here. Okay. You know what? You know what, guys? Oh my God. On Reddit, they put what maybe she was talking about, because right now it's a Sister Wives documentary, and it has the Duggars, and it has Katie Joy narrating something. Her voice is over something. So maybe that's where she was this weapon in an upcoming proposed documentary. Stavig, Affidavit, Exhibit D. Due to the nature of the lawsuit, confidential information already disseminated by defendants' egregious lies about plaintiffs, the irreparable harm already bestowed upon plaintiffs, and defendants' involvement in a documentary about plaintiffs respectfully request that the relief requested in the memorandum of law be granted. Because, you know what, now I'm thinking, okay, she was supposed to be a part of the 7M documentary, but I don't think she was. Am I right, or was she? I haven't watched the documentary. I'm making myself wait until after I'm done with this so that I don't have any of that skewing my opinions where I am trying to learn the merits of this case on my own. So please tell me in the comments if indeed she is or was the weapon in the documentary against 7M. Not against, about. I misspoke, sorry. Don't come for me. I already had enough of that. Anyway, the amended scheduling order. Defendants in their memorandum of law opposing plaintiff's motion for an amended scheduling order failed to list a legally cognizable reason plaintiff's motion should not be granted. Defendant's sole argument is because plaintiffs failed to engage defendants on the topic of discovery until the deadline for discovery had passed. As outlined in plaintiff's memorandum of law in support of an amended scheduling order, the scheduling order stated, this order may be amended only at a scheduling conference requested by either party within 10 days of notice of this order. The plaintiffs attempted numerous times to contact the court to obtain a scheduling conference in compliance with the scheduling order for the 10 days following its issuance and through the discovery deadline. Plaintiffs also contacted defendants to meet and confer regarding a stipulation to an amended scheduling order prior to filing this motion with the court, meeting its requirement under Minnesota Rules of General Practice 115.10. And that's in the Stavig Affidavit, Exhibit A and B. As plaintiffs have attempted in good faith to follow the direction of this court and Minnesota law, it is respectfully requested that a scheduling conference be held to discuss the timing of discovery, motion deadlines, mediation, and how long the parties will need for trial. Absent a scheduling conference and an opportunity for both parties to fully participate in discovery, plaintiffs request that the court issue an amended scheduling order requiring both parties to serve Rule 26 disclosures, allowing at minimum 90 days to complete discovery, and setting a trial date for after July 15th, 2023. Plaintiffs also request that if an order on this motion takes longer than 10 days to be issued by the court, that the above referenced time periods be considered as of the date of the order is issued, not the date of the hearing. In the conclusion, defendants have failed to timely answer this lawsuit, and therefore default judgment should be entered against defendants and in favor of the plaintiffs. Alternatively, plaintiffs request their motions for temporary injunctive relief, a protective discovery order, and an amended scheduling order be granted. Dated November 14th, 2022, from Dudley and Smith by Amber J. Stavig, attorneys for the plaintiffs. Bam. Boom. I think that her side would have upset a judge, with them being the ones who obviously had made mistakes, and then to be caustic towards the other side and using the words window dressing and draconian. And of course, if somebody has an illness in the family, that's terrible. But that's why most attorneys are in a firm, because they must rotate when situations like that happen. They have clients that are not affected by those family illnesses. And that's when another member of the partnership, of the firm, takes over. Because it is too difficult for one to be in that position. If this goes to trial, civil cases are known to take forever. They're not like criminal cases where you have the right to a speedy trial. Civil cases get dragged on and on. But this is extreme in all of the things that are going on in it. If you look at how fast Queen Bee's lawsuit is moving, because Queen Bee's attorney is an absolute badass, and Betty is the ultimate definition of FAFO. Think about it, what that means. FAFO. Fuck around and find out. That's what she did. Betty has continually bullied people on this platform, threatening to take everybody who laughs at her ridiculous tragedy pimping to court, to take everything from them, and to make sure that no one can get jobs and provide and whatnot, for daring to cross bullheaded Betty. So she took on Queen Bee, and Queen Bee went with her stinger and just boom, walloped. And her attorney is moving fast, because that's the way good attorneys do. This has went on for too long. Now, of course, the pandemic had something to do with it. Of course it did. And that's why there's leniency. Now, if this goes to trial, it's different. It'll be a jury, but it's not a full jury like in a criminal trial. I'm a little rusty at this, but I think that it is only 6 jurors for civil. And it used to be that it had to be a unanimous ruling, but I think that it is the majority rule. So if it goes to trial and she has 4 out of 6 people that believe that she is a journalist who had the right to say what she feels is truth to the people, then she's not going to be out any money. She doesn't have a counterclaim to them for affecting her or taking time away from her for this lawsuit. In Betty and Queen Bee's, Betty went against Queen Bee and tried to get $150,000, trying to say that Queen Bee made her fear for her life, what didn't allow her to leave her house, has people stalking her, and caused her humiliation to the effect of $150,000 would be her compensation price. Queen Bee's attorney said, yeah, right. You want to play? Well, you picked the wrong state to file in, because the Supreme Court ruled in this state that you need to go back 5 years and show every single conversation that you've ever had with any associate on anything. And let's go back to your psychological records, your medical records, and all of that good stuff too. Well, we're talking about it 5 years back, so that we can see where you were before Queen Bee laughed at you and after Queen Bee laughed at you. So Betty's going to have to divulge a lot about what's going on behind her channel and who's been running it. Queen Bee's attorney has asked for attorney's fees and a compensation basis. And I don't know what that is, but basically Queen Bee's not going to take this and not be compensated. She's not asking for what Betty did, because to try to pull that number out is not okay, but she's definitely asking for attorney's fees and fees as she's out, and the amount of stress and whatnot. She's out. So there's definitely, that one's one to watch. This one is one to continue to watch. And it's funny that clip that I found where it said that, oh, it's a good day to be Katie Joy, that, she's winning. That's because Katie Joy was saying something out of this, because obviously Robert Shin isn't going to be out going, oh, guess what happened, because Robert Shin is an adult, a business owner, and understands that there is a very serious issue here. This isn't dropping the tea on the internet. He understands the seriousness of it, and his attorney is amazing in that she did not engage in the immature excuse making that Katie Joy's side did. It's important to not engage on this platform more so than ever, because the second you engage, the pitchforks come out. They smell blood and they'll start going. But just don't. Just walk away. Don't engage. It's not easy to do. But to continue to be good stewards for our children, our families, and our community, it's important to not engage in those that continue to try to bring us down. Had Amber have engaged in this and said, Draconian? What are you talking about Draconian when you're the one who did, it would look petty, even though she would have every right to do so. So instead, she stuck to the task at hand, and I believe that she has conducted herself very well in all of this, and I think that she will continue to sail through this lawsuit as gracefully as she did in the courtroom when I saw her that day at the hearing. I didn't see some tough, oh yeah, you're window dressing, you Draconian. I didn't see any of that. I saw this little old lady who didn't know what to do against Xena, warrior princess. And that is the vision of my crystal ball. So, thank you for listening to episode 13. I hope you're having a marvelous day and you'll continue to do so. Thanks for listening. Bye-bye.